All right, let's get on to some content. I just want you to continue. We'll keep talking about this, just keep thinking about it. So I want to talk about some cross-border issues now. So, how many of you here have done international law? It's actually a compulsory subject in another life. It's a compulsory subject to the JD now, isn't it? My understanding, you can tell me if I'm wrong because I've not done the classes, if you have, is that it's got, where it's taught, it's very much a public law focus. So we're not really talking about international commercial law as much.
A lot of treaties.
A lot of treaties. There's a
international business law.
Yeah, okay. Cool, just want to understand where you're coming from. But more than half of the people in the room haven't done any international law in that sense anyway. So I just want to make some broad sort of positioning statements. So when we talk about international law, we talk about a whole heap of different things. So unlike every movie about aliens invading a place that you could have seen, there is no actual government of the world. So there is, whilst the UN, I suspect, would like to think of itself sometimes as a government of the world, while the world, sorry?
Or the US.
Or the US, yeah, true. Well, now that, Mr. Trump and his new best friend, Rocket Man, once they actually become Twitter BFFs, like maybe they will rule the world. But there is, when we talk about international law, we are talking about the laws that govern international, or govern relationships internationally. So we might talk about private international law in the sense of arrangements either between people, organisations, or between governments in relation to commerce, or we talk about public international law in the context of treaties between nations. And again, each of them are subjects unto themselves, so we're not going to do a deep dive, but I just want to give you some examples of where the issues come up and what we do. What often we find with internet or technology-based issues is that jurisdiction becomes an issue. One of the very first things that I get to talk to contract students about is why we work out where a contract is made. And generally that comes down to, under common law anyway, the place and the time that a contract is made leads to the place that the governing law for that contract is, and the time sets what the laws are at that time. So often they are issues. Now it was hard enough when people were posting letters to each other. Spent a bit of time in contract law talking about the postal acceptance rule. You will remember that that is an exception to the general rule. Essentially, the general rule is a contract comes into being at the point that the offer is accepted unconditionally. Normally, when two people are in the same room, it's pretty easy to work out what that is. If they're not in the same room, back before the internet and instantaneous communications, the exception to the rule was called postal acceptance rule, and that essentially said a contract is accepted at the place and in the time when the letter goes in the mailbox. Seems bizarre to those of us who have not done contract law, but the reason for that is that's the point at which it's out of somebody's hands. So if you accepted an offer and you put it into the mailbox, and it's 3 days later before the other guy finds out that their offer has been accepted, that other person is still bound to the contract as at the time it was put in the mailbox. Of course, now we have instantaneous communications. The law started to think about that back in the 80s in relation to telex machines and fax machines, and essentially went back to the original principle. A contract is made at the time and in the place where the offer is received. So what does that mean? I'm going to refresh some of these people who've done contract with me. What does that mean if I'm in Australia and I send an email, let's accepting an offer for a contract, an offer to to the other side in London. I send it right now, but of course they're asleep right now, so they only read their email at 8 o'clock tonight, my time. What time is the contract made? Let's assume it's just a straight offer and I'm accepting it without any variation. When they read their email, was that?
When it's received.
When it's received, what does received mean?
When they have received it.
When they have received it, what does that mean?
When it's
they've
available,
When they've read it?
when it's available to them to read it.
For the win, Artemis, for the win. When it is received on their server, so when it is capable of acceptance. Even if they're sleepy. So in other words, you can't go, blah, 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 I don't want to read your email.
Wasn't there a case, I can't remember the case or where it was, but it was about how, like for example, work email that's only accessible at work, the acceptance isn't available until work, you would normally arrive at work. Was that?
So, again, there would need to be some variation around that. I'd need to know, I don't remember that case. But it needs to be capable of acceptance. So what we see in most commercial contracts is you'll have clauses that deal with time. And the clause will say, usually a notices clause, it will say something like, notices are deemed to be received between 9 and 5 on a business day. And if they're actually received outside of that time, then they're deemed to be received on the following business day. Yeah. So basically, yeah, private law. Yeah, but in the absence of creating a particular set of rules for your own game, the law says contracts are made at the time and in the place that they are received. So, key case in this area, for those of you who like a case, was the Brinkabon Stag Stahl case. I picked a case in my head that I won't be able to spell out loud. Anybody who really wants case references, just go what's it called? Go Soapbox and remind me to give you a reference. But essentially what happened with that case is, I think that one business is in London, the other business is in Austria. I want to say, you can hassle me if I'm wrong, the principle was the same. An acceptance of a contract was sent by telex. The question became, was the acceptance in Austria or was it in London? Was it in the place that the contract was sent or was it in the place that it was received? The difference is if it was, the contract was made in London, then UK laws applied. And if it was made in Austria, Austrian laws applied. Austria is a civil system, it worked quite differently. So the parties, their initial issue, somebody sued in London, the other side has said, nah, we don't care, this contract is an Austrian contract, we're going to fight you on that point. Got to the House of Lords. Based on just the logic we just spoke about then, what do you reckon the House of Lords said? Austria, for the win with Angie, basically, yes. So it said it's made at the time when it's first capable of being read. So if the telex machine went humming and the paper rolled out in the middle of the night, that's the time, but the place is the place where it's received. And those rules still apply. Now, what's kind of interesting about this is, theoretically at least, the rules in Austria could be quite different. So if the same question had gone through the Austrian courts, theoretically at least, the Austrian courts might say, no, this is not ours, this is a UK case.
But also not jurisdictions, the House of Lords have to deal with the Austrian.
Well, it doesn't have jurisdiction to deal, to deal with the Austrian company. Okay, so companies are legal people as far as the law is concerned, and most jurisdictions, including England and Australia, will say an incorporated entity is capable of suing and being sued on its own name.
Yeah,
it has capacity.
In a different jurisdiction.
But essentially what's happened there is they've submitted to the jurisdiction for the question of whether or not, where the contract is being made. But yeah, even otherwise, if they've made a contract in England, it will have capacity in that sense. So, and again, these are the kinds of issues that international lawyers deal with all the time. So just thinking about the theory of it, so Australian law might say X applies, Austrian law, Chinese law, Indian law might say Y, and you can end up outside jurisdiction, in theory. So jurisdiction issues come up a lot when things are litigated. One of the things that we're seeing more and more though is that big commercial matters are litigated less and less. So what is actually happening is, particularly in these complex areas, and we're going to talk about a couple of these jurisdiction issues as we go through, but in some really complex areas, people don't want to air out their dirty washing and tell people how much they paid for something or deal with the tax issues in a really public forum. It's also really expensive, really complicated, and every dispute that you go to court with, you don't really know which way it's going to turn until the very end. So most people are not all that anxious to go to court. So we're finding particularly big commercial matters are being arbitrated behind closed doors, being mediated behind closed doors, or they're finding some commercial resolution. Lots of matters get settled. So we do have to remember, particularly for those of you who aren't law students, we as lawyers will go straight to, well, what's the decision? What have the judges told us in the past? But remember, we are limited in the sense of what the judges have told us in the past by the kinds of disputes that the judges have dealt with. And less complex disputes, particularly disputes relating to technology, are coming before the courts because it's a risk issue. So let's just make sure we've got some terminology that we agree with. The term jurisdiction itself tends to cover a number of different legal concepts. One of the things, actually just a little side comment, which I've made on, I'm loving this new system for being able to give feedback. I have gone through the reflections that have been uploaded, and I did make this kind of note for a couple of people, which is, for the reflections, I'm not really worried about your writing or your expression or your use of English, particularly because of the nature of that particular task. So just go for it, tell me what you think, do it. I don't mind that you do it quickly, that's great. But when we do written submissions, particularly when we're talking about the law, you need to be as precise with your language as you can. And what is going to be really difficult here is that jurisdiction in particular has a number of different meanings. So one of the particular ones I picked up actually in the reflections is somebody talked about internet securities with an S at the end, where I suspect they were really talking about internet security issues, which is fine, came out no issues at all from that point of view. But those kind of words like securities and security, so the word securities tends to mean financial instrument like a share, or maybe in an internet sense an initial coin offering or something like that. Just be really careful with your language as kind of a feed forward for written submissions. So in jurisdiction sense, we talk about these 4 different things that we might be talking about. So one is governing law. Anybody want to hazard a guess for me what they think governing law relates to? What a more expansive definition than that? I hate it when the middle of the room is blank, by the way, when there's nobody there, because I have to like go this way or that way. What is governing law? What are we talking about when we're talking about governing law? The law that governs how this, the law that governs how an area could operate.
Yeah. Or maybe, or is it the entire legal framework?
I think probably we're closer to the first one, an area. Really, governing law we think about in a private law context. So what law have the parties chosen to govern their relationship, their contract? So often in a contract you will see a clause that's headed up governing law. So the parties have agreed that the laws of Victoria will govern their contract, or the laws of Singapore will govern their contract. One of the things I would suggest that you do is go and have a look at the terms and conditions on something you use on the internet. Scroll down, I should say, trolling down is not something I should encourage anybody to do. Scroll down, see if you can find a governing law clause. What laws? You will find some tool that you use all the time, something like Facebook, Instagram, Snapchat, whatever it is, likely governed by the laws of a country you've never been to. It might surprise you which ones they are. They might be New York, might be Los Angeles, California, might be a favourable tax jurisdiction. There's lots of contracts that are governed by the laws of Ireland. Jurisdiction in its very broad sense, that's in a really bad order, I should have had that first. When we talk about classic jurisdiction, what are we talking about? They're nodding, but they're talking about something else. Tax havens. Everybody should spend at least a minute a day talking about a tax haven. Ideally in a coffee shop. It's nothing better than sitting there.
It's more to do with like borders.
Borders, yeah. What jurisdiction, what is the power of a court or a government over a particular issue? So it is about borders. So the kind of point that Daniel made before, what ability does a particular court, does it have jurisdiction over a particular individual or a particular place? A good example might be Yep. So part of what these companies, large companies, are arguing is, we don't operate our business here. You don't have any jurisdiction over us, even though people do. And so we'll look at some of the classic cases in that. And of course, because those of you who don't have a life after finally getting the canvas might have read some of the materials I gave you about the Gutnick case, for example. This idea of forum conveniens, Latin. You guys who are not law students will need to get used to a little bit of Latin. Lawyers use it a lot, usually to say things that are really clear in English, and our clients wouldn't pay us a lot of money unless we use fancy words. Forum conveniens, what does that mean? What is that about? Sorry? The forum of choice. Absolutely. So often when you've got international parties, so a good example of a forum conveniens is Singapore. International parties doing international deals will often say, okay, we're a multinational company based in the States, we're a multinational company based in China, we want to do these deals together, but if we have a dispute, the American company is saying, I don't want a Chinese court dealing with it, they won't treat me fairly, and the Chinese court are saying, we don't want an American court dealing with this, we know they won't treat us fairly. So they choose a forum that they both trust. So that's, we see in international, particularly when we're talking about technology deals, we see forum conveniens come up quite a lot. Then the other issue that comes up, which is very closely related to the technical concept of jurisdiction, is the question of enforcing judgments. So it's one thing to have a right to sue someone. It's very closely related to winning that suit. But it's quite another thing to be able to go to another country and collect your winnings, to be able to extract money and to have a judgment that's made in Australia enforced in China or enforced in India, enforced in the States. So how do we do that? So they're the kinds of things that I just want to talk about over the next little while. So, okay, I forget that I have slides that give you some more information. So John Pfeiffer is a very good example of a case about jurisdiction. The High Court basically held that questions of jurisdiction need to be kept separate from the questions of the law. So under Australian law, the court will first consider whether it has jurisdiction to consider a matter before it starts to consider the law itself or how the facts apply. So there are a few things I want to talk about here. I'm not sure how we're going to go. I'm going to do a bit of racing for a minute just to make sure you get the information. Some of these slides are going to be quite wordy, but they are available for you to have a look at. They're as much as anything to remind me about the cases. So a lot of the reason for coming to this kind of issue is around the question of, on the internet, if something happens in one place that can be seen everywhere else, what does that mean? So one of the most interesting places or cases in this regard is Yahoo and LICRA. I will not be able to pronounce the words in French. Have we got a French speaker here? Sorry?
Yes.
We have. Awesome. Can you see that? What LICRA stands for? What she said. Essentially,
League Against Racism and Anti-Semitism and the Union of Jewish Students.
so the League Against Racism and Anti-Semitism and the Union of Jewish Students. It's essentially a club that was or is devoted to ensuring that Nazism is a thing of the past. It's at risk of completely oversimplifying some amazing group of people. So in France, it is illegal to buy or sell Nazi memorabilia. Yahoo, back in the day, this is an old case, Yahoo used to run an auction website. So this is, I don't have a date on there, which is a bit annoying. But basically, Yahoo used to be like a bulletin board. Yahoo was one of the biggest things on the internet for a very long time, as we got into Web 2.0. And basically, people were able to buy and sell Nazi memorabilia on this site. And so LICRA brought an action in France, essentially claiming that their auction service needed to be shut down and that they were not complying with the French criminal code. Yahoo defended the action on the basis that the auctions themselves were conducted under USA law, that their servers were in the USA, that they ran their business in English, and that they had absolutely no control over what people put on it or took off it. They absolutely agreed that French people in France who advertised Nazi memorabilia were not complying with the criminal code. They absolutely agreed that French people in France who bought things on this website were in breach of the criminal code. They said, we're not. We're just a platform. We're based in the States. This is nothing to do with us. So that raises a really interesting question, doesn't it? Like, you just want to smack them and say, no, you are selling Nazi stuff. You are wrong. Take it down. But it raises a bigger philosophical question about whether they should do that or not, or whether if that's what they're doing. If they were providing a platform that provided, let's say today, Korean translated news about things that Kim Jong-un was doing, and that might be, non-sanitized news, that might actually be a crime in North Korea. Would we necessarily think that was a bad thing, to be able to provide information to the citizens of Korea in that way? Yahoo's argument is kind of the same thing. Sorry, I'm apologising to the short-sighted amongst us for really small text on the slide, but they are available for you to read. So, Yahoo's arguments. Servers were in the US, services were primarily aimed at US citizens. They've got the First Amendment. First Amendment is very important, and obviously they govern the whole world, as Artemis mentioned earlier, so everybody should be aware of that. and that they have a right to freedom of speech, and any attempt to enforce a judgment in the US would be unconstitutional as a concept. And so they contended that the French court was incompetent to hear their case. Now, again, we're talking here using legal language. So they weren't arguing that the court itself was not competent or that it was incompetent. It was incompetent to hear this case. Another example of the precise language. So what did the French court say? They did not like being called incompetent. They said, first actually they were a little bit sucky about it. They said, what we need is to get an expert to have a look at this and see if it's really true that they can't find these things and take them down. Is that the case? God, I can't even read it on my, sorry, now I've made it go blank. I didn't mean to do that. There we go. Sorry, let me have a look. So they said, though, what did they say? There were sufficient links with France to give it full jurisdiction. They said people are buying and selling stuff here. So we think we have jurisdiction to do something here. The display of the objects and viewing the objects in France causes a public nuisance, and it's forbidden under the law. And because Yahoo was aware that French citizens could use this service, and because it also displayed French language advertisements when their services were accessed from France, so the bulletin boards themselves were in English, but the advertising material was associated with this French, they said that's a sufficient enough link to France that we have jurisdiction. So Yahoo said, well, actually this is impossible. You know, internet, technology, really hard. This is stuff you guys don't understand. So we can't actually comply, so you're going to have to just deal with the law differently. This court-appointed expert that they had said that as of the year 2000, 70% of French internet users could be identified by their DNS. So it's saying, actually, I'm sorry, Yahoo, you actually have, it's really easy for you to tell where people come from. So you can actually block it to those people. And the court said that Yahoo needed to comply with the original injunction, and within 3 months, that is, so the original injunction was stop French people from looking at it or pull it down altogether, or they were going to get a fine of 100,000 francs a day until they did. So what's that? 15,200 euro. In Google dollars, that's like pretty much nothing. That's like 1.3 Bitcoin or something. But it could add up very, very quickly. So what did Yahoo do? Took its bat and ball off to California. Said, we want an order, Mr. California judge, that says that we can keep doing this in France. So they didn't actually appeal in France. They went to San Jose and they wanted to get an order that said that the judgment, that claim for that 15,000 francs a day, couldn't be enforced against them. And controversially, essentially the judge at first instance agreed with them. Jeremy Fogel found that it would be inconsistent with US law to limit their freedom of speech. So essentially, a district judge in California has said it would be unconstitutional in America to stop somebody selling Nazi memorabilia in France. Well, in fact, the selling is actually inappropriate or imprecise language on my part, because what they were doing was providing a platform where people could advertise. So essentially telling people that they had something, showing pictures of Nazi war memorabilia, that is an expression. So what do we think? Do you think an Australian court would do the same thing?
What's the French?
What did the French court do, actually? Well, let's go through the appeal. At the end of the day, there's an order, right? Okay, so it hasn't been appealed in France. So this does actually get appealed. But I do want us to stop and think about it. Maybe, because it's really easy to look at this and think, what? But then I think about some of the things that Australian courts have done. The island of Papua New Guinea decided some time ago now that it was unconstitutional for them to hold people in detention in that place.
So,
Please, that's what you're here for.
so to be clear, Yahoo was providing a platform for sale. So Yahoo's not actually selling the goods, which is what the law in France is trying to do. So how can we go after Yahoo as opposed to the sellers of the goods?
So again, I'm not going to pretend I know the intricacies of the French law in this regard, but essentially what they're doing, what LICRA is trying to do is saying, instead of going and finding every French person who gets involved in a transaction, what we want to do is shut the shop down. So again, those of you who've done contract law will remember those like body entrapment cases, as I think of them. They seem to always involve birds or flick knives. That, basically somebody has turned up at the shop and it's, Mr. Quad has said, oh, I can see that you've got that flick knife behind the counter. How much is it? And then a price is given, and they buy the knife and then they say, hello, 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 I'm going to take them in down the nick now because it's an offence to offer flick knives for sale. And our shopkeeper says, no, I didn't offer them. It was an invitation to treat. You offered to buy it. I just accepted your offer. That is not a crime.
But in that instance, the shopkeeper is party to the sale, whereas in this instance,
well, as it's sort of where I was going. It's like what they're trying to do is stop the shop. They're actually trying to shut down the shop, not just the transactions that are happening inside it. So they're saying, and again, intricacy of the French
from ever existing, so therefore they're stopping any shop, whether that involves a third party transaction happening or not.
So the offence here, it's exactly the equivalent. So assuming, don't know the intricacies of French law, but we're assuming that the law says it is an offence to even show a flick knife in public.
And then the second question I have is in relation to the French court's capacity to enforce.
And this is what this is doing. So what Yahoo's doing now is saying, okay, we've got this order against us. We think it's technically too difficult and too expensive for us to comply with it. We don't want to shut down the door to French people coming into this space. That's too hard for us. So what we're going to now do is go and get an order from our local court that says your order isn't enforceable where our bank account is. Does that make sense? It doesn't make sense.
So then
And that's okay.
how are two competing courts, French and the Californian, whatever, who decides who wins there?
Well, this is, and I'm glad this is coming out because this is really pointing out the complexity of these conversations. So this is a classic enforcement issue. It's one thing to get an order. The next part is, can you enforce the order? So let's bring this into modern times or look at it slightly differently. Anybody ever bought anything from AliExpress? Really? Oh, a couple there. AliExpress is one of the biggest businesses in the world at the moment. So what's his name? Jack Ma. Biggest. Yeah. So it's basically what it is. It's a platform. It's an internet business, right? So a whole lot of businesses, largely in China, more and more of them in Russia now, they sell their stuff, right? And what they do is like a big eBay. You basically go onto AliExpress. You find something that you're interested in. I bought this on AliExpress. Little multifaceted dongle that I can attach. I go and I look for what I want. I find the price that I like, I look for a provider who's got 5 stars or whatever, just like an eBay. I usually go for the people who won't charge me postage, and off they go and it comes. So I bought this little consumer good. I think the average amount of money I spend on AliExpress is about $10, but I've bought all sorts of things there. You know, when they advertise funny little kitchen gadgets on Facebook to me, I go and look for them on AliExpress and buy them at a tenth the price and get them sent over that way. I'm sure that's how they would have come anyway. But just say my little dongle there didn't work. The consumer laws in Australia, just take my word for it at the moment, let's not unpick it too much, but the consumer laws in Australia would say that's a consumer transaction. Doesn't matter that I bought from someone overseas. I have the right to exchange it or get my money back if it didn't work. Well, that's all well and good, but I've gone from, I bought it from Guangdong, best product ever, do not put negative comments, whatever they're called, store. And I said, okay, I want my $7 back, or I want a new one. And they just say they don't do it. By the way, AliExpress is brilliant, and on the whole, if you have a problem, you'll find that they'll send you something straight away. It's actually excellent. But let's say they didn't. Let's say I got the 1 in a million person that I could then leave a negative comment and nobody would buy from again. Didn't do it. And I say I march off to court to get an order requiring the payment of my $7 or I'm incredibly rich but incredibly stingy. So I've gone off to, and I've got that order. The law of Australia is quite clear that I have the right to that. But if I then front up in Guangdong, ready to exercise that order, it's completely a matter of Chinese law whether or not that order gets enforced. It's exactly the same issue here. And so these are the kinds of issues that have become so much more taxing since the expansion of the internet. So it's one thing to have a right under your contract or as a matter of law. It's another thing to be able to enforce it, which is why everybody who does contract with me understands that the best thing to do is get the contract right in the first place and to mitigate your risk in all other ways, because we don't be litigating with all of these other issues. Does that help you understand, Daniel, what I'm talking about? Don't have to say yes, you're amongst friends. Can I move on and we'll circle back, because hopefully it'll all make a little bit more sense as we go. So what do the courts say on appeal? Basically, what's there? Exercise of jurisdiction is consistent with these requirements of minimum contacts and fair play and substantial justice. Where 1, a non-resident defendant has purposefully directed its activities or consummated some transaction with the forum or as a resident of the forum, or performed some act by which he purposefully availed himself of the privileges of conducting activities in the forum, thereby invoking the benefits and protections of its law. 2, this is a cumulative list, the claim arises out of or in or relates to the defendant's forum-related activities. In other words, if you are going to set up your business to take advantage, this is American law, to take advantage of the laws of another place, you set up your business in a way that means that you are conducting activities in that place, dealing with consumers in that place and taking advantage of that place, then you have an obligation to comply with the rules of that place. So on appeal, they lost. So again, there aren't that many of these cases around. So this is a 2000 case. It's not Australian law, so this is not precedent here. And its persuasive value is, well, in effect actually strong, but if we do the legal analysis, it's actually quite poor, because we are dealing with a set of rules that are quite different from our own rules here. But in practical effect, as more and more treaties have evolved looking at intra-jurisdictional commerce, this is kind of a set of rules we work with. If you are going to play in our playground, you have to play with our rules. So, district court, but then ultimately, it made no allegation that it could lead a court to conclude that there was anything wrongful in its conduct. So ultimately it found that it couldn't deal with it. But then Yahoo went for it. So let's look at the concept. It's not quite broke yet. Poor Melissa, I'm sorry for her. Anyway. Okay, so anybody recognise this guy? Got some
Melbourne. Oh, that's Melbourne president.
Yeah, president of the Melbourne Football Club. His name is Joseph Gutnick. He's also a rabbi and an investor and a colourful Melbourne identity, I think you could call him. And Barron's is an online, largely online investment publication. Again, this is an old case, 2002, but it was basically investment notes, sort of like a old version of Hot Copper for those of you who play in the investment space. An article was written by Barron's back pre-2002, don't think they have the date, called, where they said Unholy Gains was the title. And it basically talked about Joseph Gutnick's business dealings, essentially accusing him of using money that he amassed from religious charities in his own investment endeavours. Basically, Mr. Gutnick was hurt, very, very hurt by these assertions. He believed he had been defamed and he wanted to sue. So I'm just trying to think of the best way to explain what's going on. So a few people in here have done torts. What's defamation? Can we have a description of what defamation is? You can pull it online. You need 3 parties. Nice.
So you need the person who is sending out or disclosing some kind of information about another party that is then received by the third party, and the nature of that information is defamatory.
So basically, in order to establish the cause of action, you need 3 people. You need somebody or 3 parties. I don't sort of humans. You need some information about one party transmitted by another party to a recipient.
I think it's the
And
it's a defamatory matter that has to be published.
yeah. So so I actually want to pare it back. What do we mean even just by defamation? It needs to be untruthful, it doesn't necessarily, the truth is offence in some places, but not always. It needs to be a negative statement about someone. It needs to tarnish their reputation, needs to hurt them in some way. Have I spoken over the top of you again? Sorry. No, fair.
I gave a great definition.
An awesome definition, but noisy me, you couldn't get over it. So in this particular publication, the detail of it's there, but let me actually show you what had happened here. Basically, the newsletter, there were 5 printed copies, many printed copies in the States, but only 5 of them were sent to subscribers in Australia. Actually, as a matter of fact, it appears that they got lost in mail anyway. They never actually physically arrived on our shore. There was an online magazine though, had 500,000 subscribers, roughly 1,700 of whom were based in Australia. And so the question became, in order for the law of Australia, if these statements were defamatory, did it matter where it was published from or where it was published to? Is this the case you drew in torts, by the way? Okay, yes and no, depending on where you're at. So, So it's alright, it's an old case, but it's like, I'm sure there are many others that deal with it. It's just because I come from fintech and I find this particularly hilarious, I particularly like this one. So here we go. This is Justice Callanan. I think it's sometimes nice to give face to a judge, don't you reckon? Again, same rule. Depends on the face, of course. Oh, I shouldn't have said that on a recorded device, should I? If people wish to do business in, or indeed travel to, or live in, or utilise the infrastructure of different countries, they can hardly expect to be absolved from compliance with the laws of those countries. The fact that publication might occur everywhere does not mean it occurred nowhere. In other words, Justice Callanan was of the view that, well, they did reach the view that the statements were defamatory, and that the defamation happened in Australia. So it was published into Australia. Again, every country different, all the rest of it. These are the kinds of issues that those people who are doing business on the internet or in the cloud or using apps where for their customers, their stakeholders could be anywhere, need to be able to think about these issues. The author of the article, so not Barron's conceded basically at this point, the author actually appealed to the UN. So, oh, by the way, for those who might not have recognised, Justice Callanan is a High Court judge. This particular matter went all the way to the High Court, the highest court in Australia, to get to that point. So he actually went to the International Court of Justice, but ultimately he lost. It was settled, and he ended up paying so a journalist ended up paying quite a substantial amount, as I understand it, of Gutnick's fees. I've got Jeffrey Robertson QC there because he in fact acted for Barron's all the way through. I think that's kind of an interesting little case. In that text that I've got on the original slide, it's just not... it's got some of the detail of it there. It was to do with, all I know is from the case, but it was to do with an allegation of inappropriate use of money that had gone to the charities. So what the article associates stocks promoted by Gutnick, associated him too with a man called, I don't know how to pronounce his first name, but Goldberg, Nachum, I think it is, Goldberg, who was apparently a convicted tax evader, and some other person who was awaiting trial for stock manipulation in New York. So, let's go look that way. All right, what are we going to say here? All right, so as is the way of the world, when the common law gets messy, governments eventually make some laws and also legislation to deal with these issues. So the Foreign Judgments Act essentially deals with these kind of issues. It identifies now, so whilst it's been in place since 1991, it's been amended a few times and we end up with a list. So there are currently 36 different jurisdictions where orders from the courts in those jurisdictions will be enforced in Australia. So they include UK, New Zealand, Canada, Japan, Korea, I probably should say South Korea there, I suspect that's the Republic of Korea, Israel, Italy, Germany, Gibraltar, of all places, and others. And the court needs to be satisfied that there would be a substantial I can't say it properly. Thank you. That's one of those words I can never say. It's like phenomenon. So it needs to see that there's going to be a quid pro quo of treatment between the two jurisdictions. It's 3:25. Gee, I talk a lot, don't I? Contract law is another way that we deal with relationships across borders over the internet. So, in this case, Ace Insurance and Moose Enterprises, contracts. So Moose Enterprises, some of you might have bought their toys. They They do little like jacks and I don't know, anyway, they're kind of cute, but they sell stuff all over the world. So the contract in that case talked about the law of New South Wales, but the action that was brought was in a different jurisdiction, so brought in California. Might not see how to remember this. So Moose brought a proceeding against ACE in California, seeking a declaration that ACE was obliged to fund Moose's defence of some class actions that were brought in relation to toys that they sold. By bringing this insurance proceeding, as it was, in California, they attempted to benefit from laws in California which might have required ACE to continue funding, wouldn't be limited in the way they would have been under Victorian law. So they're essentially forum shopping. They're looking for a forum that's going to give them the best result. It was relevant in this particular case that the insurance policy under which this particular action was being brought contained a clause that said this: should any dispute arise concerning this policy, the dispute will be determined in accordance with the law of Australia and the states and territories thereof. In relation to any such dispute, the parties agree to submit to the jurisdiction of any competent court in a state or territory of Australia. So ACE relied on that clause when it applied to the New South Wales Supreme Court from an anti-suit injunction. So in other words, it's saying, no, we don't want you to get the benefit of the additional bonuses you might have in California. We want an order from a New South Wales court that says, sorry, contract says New South Wales, you can't sue anywhere else. Again, can you see how the complexity arises? So Justice Brereton here observed that the question of whether the jurisdiction clause conferred exclusive jurisdiction on Australian courts is ultimately a question of construing the contract. And essentially, he decided that the jurisdiction clause in the case was exclusive jurisdiction clause. In other words, it prevented the use of other jurisdictions. So in a sense, or in essence, the parties had in their private law, made between them their contract, limited the places in which they could bring an action to the place that was stipulated in the contract. So again, many contracts will have a choice of law or a governing law clause. Whether that's exclusive or non-exclusive can depend on the construction. But many of the contracts that you enter into, not necessarily with any particular consideration of the terms, for example, the terms that you have with a social media provider, will stipulate exclusive jurisdiction, most likely in a place where you are not. And the place where you are, well, New South Wales, it's not where you are, but it's analogous and highly persuasive, says if you've entered into a contract on an exclusive basis with an exclusive jurisdiction clause, that's the jurisdiction. Now, obviously, in relation to a number of things, when we're talking about consumer rights, etc., there will be a consumer law overlay that doesn't give a toss about your external jurisdiction, but it is worth noting that. Contracts online. For those of you who have not done contract lawyers think about contracts slightly differently from commercial people. When we're looking at forming the contract, we're needing to identify these 4 things to make sure the contract actually exists. Agreement. From a legal perspective, when we talk about agreement, we're talking about 2 things. Is there an offer, and has that offer been accepted? Usually in commercial context, an offer is ultimately the written down terms of the contract. Because the way that the law works, and I don't want to overcomplicate this, and it takes me 6 weeks to get to this point in a normal subject, but the way the law works is agreement is made at the moment that an offer is accepted. And so working out who the offeror is and what the terms are is an important part of that process. So an offer, in order to be capable of becoming an agreement needs to be capable of acceptance on its terms. All of the material or important terms need to be contained in there. Now, it doesn't, under Australian law anyway, it doesn't necessarily have to be written down. There are some circumstances where it must be written down if some legislation says so. It doesn't necessarily have to be written down. You can have a verbal offer accepted verbally or in writing. You can have a combination of the two. The other thing that you need that's often really important is this idea of consideration. For our purposes, we could call that price. But consideration isn't always money, and it's not always valuable. But as far as what lawyers are looking for, and this is one of the reasons why we use this technical language, you call it consideration, is because while it's analogous to price and it's like price, it's not always price. So that's all I wanted. The other thing is, and this is a tricky one in the online world, is we're looking for intention. We're not actually entering into contracts by accident. We want to understand that it is in fact a contract, and that by that, that parties intended to be legally bound. And so a lot of the old law in this regard really looks at, well, what happens if it's in a social or a domestic context? What about promises that you make to your friends or family members? When are they actually, when is there the requisite intention? With commercial arrangements, we usually expect intention. And it's interesting, it's something I've pondered a little bit as we look particularly at, one of the things that can impact even when a contract's made, its enforceability, contracts with children. And we look at the contractual nature of our relationship with social media providers. That we use social media under a license and under terms and conditions. And the extent to which we think of that as a commercial relationship or expect to be bound by that relationship. And then the final thing that we need to see in order to have an enforceable contract is certainty. And certainty, I love drawing this as a circle actually, and because it reminds us that of the importance of the offer. Because the offer needs to contain everything that we need in order to form an agreement. It needs to be capable of acceptance on its terms without variation. So it needs to be sufficiently certain. At risk of boring you entirely, sufficiently certain has three different elements. So one of them, is it sufficiently clear? Like, do we understand what it is? Is it sufficiently complete? Are all of the important things, the essential terms caught up in it? And lastly, is it not illusory? I hate those other negatives, but that's the way we talk about it. And by that I mean, are both sides making promises? Because if one party has such a broad discretion that they're not really making any promise at all, it's called an illusory promise. And so an illusory promise, it will fail for want of consideration or price. Okay, so why does it take me 8 weeks to get to that point in contract law? Because I reckon that was a pretty good explanation. No cases, no complexity. Happy to go through that again with people who haven't done contract law at some point. But once we've got a contract, under Australian law at least, then we start to ask ourselves these other questions. Does everybody have capacity to contract? In other words, under Australian law, if you don't have capacity, that means if you're not an adult, if you're drunk, inebriated, you suffer from some mental impairment, it might be, it's not always, that there may be difficulties in enforcing the contract against you. Unless, of course, it's for something that you need. A range of different exceptions there. Are there some formalities that are required? So, in particular, if I want to buy or sell land, even though I can make an enforceable contract just completely verbally, it won't, I can make a real contract verbally, it won't be enforced by the law unless it's been written on paper. Because there's a statute that says that's what has to happen. Similarly, if I go and knock on your door and sell you a vacuum cleaner, I need a piece of paper as well, because there is a law that says door-to-door sales need to be supported by documents. And so that really goes to this question of, is there an overriding statute? So, for example, I could have a contract here that has all of these elements and looks like a contract, smells like a contract, under which I can sell you a teenage girl on the dark web for Bitcoin. But there are statutes, thank heaven, that will override and send me to jail, and send you to jail too if you try and enforce that contract.
There's an interesting podcast on a podcast called Dead Sex and Money, and it's about how you buy Bitcoin into prison. I can't remember his name.
Not the inventor, but I know the one, the Silk Road guy.
No, he didn't create Silk Road, he created Bitcoins. And so what he did was, he didn't create dark web, he created just Bitcoins.
Oh, right, okay,
But
this might be the different
He
one.
wrote to these people saying, I know that you're doing this, please stop.
Oh,
So
yeah.
because he didn't report it straight away, he went to prison because he was aware of it.
Yeah. He actually created a Bitcoin exchange, and there is a Netflix, one of the first exchanges, there's a Netflix documentary on him. I will send the information to you. It's actually quite fascinating. So he created a Bitcoin exchange, recognized that people were buying and selling Bitcoin for illicit purposes on Silk Road, so to buy and sell drugs, to buy and sell humans. Pretty nasty stuff was happening on the dark web. It continues to happen, I have no doubt. And ultimately, and this documentary is pretty damning about actually what happened to him as well. I mean, it comes very much from a supporting, I can't remember his name either, of this guy's point of view, but it's pointing out that this is all happening in part in response to the GFC, and to this day, no one in a major bank who was involved in the scandals that happened that resulted in the GFC has gone to prison. The pyramid sales guys, but the people who actually created those synthetic instruments and who manipulated the market have not. And yet this 25-year-old guy who set up a Bitcoin exchange, who's become aware of what's going on and has tried to do something about it, I think he got 5 years or something.
He did sell it for it.
That's all right. I'll find the link and send you. There's again, this could be an area that will interest people as they go. Common law can also recognise and enforce judgment of competent courts to which the Act itself doesn't apply. Looks like I have messed up my slide order again. Sorry about that. Yeah, I think we've spoken about some of these things. This slide obviously should have fitted after the slide dealing with the Jurisdiction Act. It's also worth noting that there are also possibilities to bring actions in equity or to think about cross-border relationships in that way. You have a convention, the Hague Convention. It's been around since 2005. Australia's not a party, but many of the international conventions and international relationships that arise in relation to the way we do business on the internet or in the cloud reflect the principles that are in the convention itself. Joint Standing Committee that reported to Parliament this time a year ago recommended that we take action. It's gone very, very quiet. I am interested in whether or not Brexit has impacted the outcomes there. I'm not sure. Actually, I'm going to go back that way. There's a couple of slides. Oh no, I will go to the next one. Basically what the Hague Convention says is that contracting states are obligated to recognise and enforce judgments rendered in accordance with the jurisdictional provisions of the Convention itself. So where recognition or enforcement would be manifestly incompatible with the public policy of a requested state, including situations where the specific proceedings leading to the judgment were incompatible with fundamental principles of procedural fairness in the state. International sales of goods fall out of this, and Australia is a party to that, but there are some major absentees. Hong Kong, India, South Africa, Taiwan and the United Kingdom are not parties to the International Convention for the Sale of Goods. Basically in Australia, the provisions of that are implemented largely through the work that the ACCC does, so the Competition and Consumer Act and the Australian Consumer Law. Because it's B2B, it actually falls within state jurisdictions, but it's codified and essentially run by the ACCC. So the provisions have precedent over existing Australian law and again oversight. So what is it and what does it actually mean? It applies a uniform set of rules for international sale of goods. So a framework for consistency. So why does this matter? Ultimately because there is no boss of the world, despite what Donald Trump thinks. And commercial people value consistency. And as you learn, as it's in a contract, we value consistency over fairness often. We want to know that rules will apply the same way each time, because that's how commercial people mitigate risk. It doesn't apply to the sale of goods to consumers. But in Australia, we have the Australian Consumer Law that will apply. Enforcing it is a difficult thing. What does it deal with? So I'm going to let you have a break any second now, I promise. It deals with the formation of the contract of sale, the rights and obligations of the parties, but it doesn't deal with the validity of the contract itself. So it doesn't look at things like fraud, it doesn't deal with undue influence, capacity to contract, etc. It does approach internet contracts from a civil law perspective. So it asks where common lawyers are used to thinking it doesn't. It's like dealing with children. It doesn't matter what you said, it matters what I heard. In the civil law concept, it does actually matter what people subjectively do. So if the approach isn't appropriate though, then it adopts the objective approach of the common law court. So again, these are concepts that might be slightly unfamiliar to those of you who haven't studied law. So understand, I'm quite happy to talk to you separately about that, the difference between thinking about something subjectively and thinking about it objectively. But we can move from there. Okay. Here we go. That's just my little reference list for you. How about we stretch our legs for 10 minutes? And I'm sorry, I'm going to throw more information at you shortly. So 10, 15 minutes? Let's make it, we'll come back at 4.